1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်980 MARIAPPA, CHETTIAR and two others, appellants versus SHRI, VRAJLAL, NARANDAS, DESAI and four others, respondents. ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before Uttarpe Judge MARIAPPA, CHETTIAR and two others, appellants versus SHRI, VRAJLAL, NARANDAS, DESAI and four others, respondents. Code of Civil Procedure, Order 22, Rule 2 and 4, Applicability to appeal, Abatement of appeal, no abatement, though the legal representative of the deceased appellant not brought on the record if the right of appeal survives to the surviving appellants, application of the test, together the respondents could sue the surviving appellants in the trial court in the absence of the deceased appellant. The respondents, who are trustees of a temple, instituted a suit against the appellants. One of the appellants died and no substitution was made. Hell, if a case comes within the ambit of Rule 2 of Order 22, Civil Procedure Code, the appeal will not abate in such a case, even though the legal representative of the deceased appellant is not brought on the record, inasmuch as the right of appeal survives to the surviving appellants. On the other hand, if the case falls under Rule 4, where one of the appellants dies and the right to appeal does not survive to the remaining appellants, the appeal will abate so far as the deceased appellant is concerned if no application for substitution is made within time. The test to be applied is whether the respondents could have sued the surviving appellants in the trial court in the absence of the deceased appellant. If the answer is in the affirmative, the case must belong to the category under Rule 2 and the surviving appellants will be entitled to proceed with the appeal without bringing the legal representative of the deceased appellant on the record. Mr. B. K. Sen for the appellants, Mr. Archer B. for the respondents. Uttarpe Judge, this order relates to the question of abatement of appeal. It is not in dispute that the first appellant has died on 5th February 1966 and his legal representative have not been brought on the record within the prescribed time. The learned advocate for the respondents therefore contended that the appeal has abated as a whole. The law relating to abatement necessary for the present purpose is to be found in Rules 2 and 4, Order 22, Civil Procedure Code, the relevant portions of which read 2. Where there are more defendants than one, and any of them dies, and where the right to sue survives against the surviving defendant or defendants alone, the court shall cause an entry to that effect to be made on the record. and the suit shall proceed against the surviving defendant or defendants. 4. Where one of two or more defendants dies and the right to use does not survive against surviving defendant or defendants alone, or a sole defendant or sole surviving defendant dies and the right to sue survives, the court, on an application made in that behalf, shall cause the legal representative of the deceased defendant to be made a party and shall proceed with the suit. These rules apply mutatis mutandis to appeals. A perusal of these rules showed that if a case comes within the ambit of Rule 2, no substitution is necessary. The appeal will not abate in such a case even though the legal representative of the deceased appellant is not brought on the record, inasmuch as the right of appeal survives to the surviving appellants. On the other hand, if the case falls under Rule 4, where one of the appellants dies and the right to appeal does not survive to the remaining appellants, the appeal will abate so far as the deceased appellant is concerned if no application for substitution is made within time. The test to be applied is whether the respondents could have sued the surviving appellants in the trial court in the absence of the deceased appellant. If the answer is in the affirmative, the case must belong to the category under Rule 2 and the surviving appellants will be entitled to proceed with the appeal without bringing the legal representative of the deceased appellant on the record. Thus, it has been held in M.T. Lakshmibai vs. MARIAPPA 1, where the right to sue is fully represented by the surviving plaintiff or defendant already on record, Rule 2 applies, and 1. It would not be fully represented unless some person not already on record is added as a party, Rule 3 or Rule 4 applies. In Sankru, Mato and others versus Boju, Mato and others too, it has been laid down that the test whether a right to sue survives in the surviving plaintiff or against the surviving defendants is whether the surviving plaintiff can alone sue or the surviving defendants could alone be sued in the absence of the deceased plaintiff or defendant respectively. See also Guru Prasad, Sukul and another verses, Tarini, Charan, Debnat and others 3, where it was ruled that where there are several defendants to a suit, it is possible for one defendant to press an appeal as against the whole decree upon a point which is common to all the defendants, and the appeal does not abate on the death of one of the defendants. The first of the instant case showed that a piece of land in Gandogali Quarter, Rangoon, with the temple thereon, belongs to a trust known as the SHRI Bhutanath Mahadeva Temple Trust, and the respondents claim to be its duly elected trustees. The appellant refused to recognize them as the trustee, and they inserted a public notice in one of the daily newspapers that a public meeting would be held on a certain date in the temple premises for the purpose of electing trustee of the temple. Thereupon, the respondents instituted a suit in the Rangoon City Civil Court and obtained a decree against the appellants that they were duly elected trustees and that the defendants were restrained from interfering with the management, control, and administration of the trust by the respondents as trustees. It is obvious from the facts of the case that the respondents could have continued their suit in the trial court against the surviving appellants in the absence of the deceased appellant, applying the test which has been mentioned above. I'm of opinion that the appeal does not abate, although no substitution is made on the death of the first appellant. The fact that the first appellant is dead and the right to appeal survives in favor of the surviving appellants will of course be noted in the proceedings. In the circumstances of the case, there will be no order as to cause